Q&A live stream on NewsNation, your number one go-to cable news station. I'm very excited to join all of you today because there's been a lot of questions on the Idaho 4 Bryan Kohberger case. There's been questions ranging from the gag order, which is coming up for hearing, I believe, on May 22nd, or scheduling hearing. And then there's been a lot of questions on the discovery noncompliance by the prosecution. And of course, today, the big news is that Bryan Kohberger is indicted. I am a criminal trial attorney of coming up on almost 2 decades, 20 years. I'm old, and I'm also a legal analyst for NewsNation. I recently joined NewsNation. I've been on media for all platforms for about 15 years, but it's really wonderful to join this wonderful family of amazing veteran journalists and reporters, and the platform and the NewsNation all over is just so dedicated to the coverage of crime stories. And Ashley Banfield today broke the news that Bryan Kohberger has been indicted by a grand jury. So there's a lot of questions about why did the prosecution do this now? Why didn't they do it before? Why did they do it at all? And so I'm here to really get all of your questions answered. And I know some of what the questions are, but I'm looking forward to hearing from you, interacting with me during this live, and I hope that I can get some of these questions answered for all of you. So I think we could first go to the latest, which is the indictment. So Bryan Kohberger was initially charged by complaint for the brutal murders of these 4 Idaho students. He's been charged in Latah County, and there's also a burglary charge, which is the least of his worries, but it's really insurance for the prosecution. And I kept saying, why did the prosecution not move forward to the grand jury indictment? Because it's really, this case is prime for indictment. It has been. The idea is that when you have a highly circumstantial case with some questionable evidence, the DNA has been questionable. The cell tower pinging with the triangulation issues has been questionable. There's been a lot of sort of dots to connect. And this is a case that's perfect for grand jury indictment, because the idea is that the prosecution does not want the defense to have the opportunity to poke holes in its case and witness testimony that comes up in a preliminary hearing. So again, a preliminary hearing is to establish probable cause that a defendant there's enough probable cause for the defendant to stand trial, essentially. And at that preliminary hearing, which was initially scheduled for June 26th, we would then hear from the defense. We wouldn't hear because there's a gag order, but the defense would essentially participate in that. They could bring their own witnesses to impeach prosecution witnesses or refute their case. They would also heavily challenge and cross-examine all of the evidence that the prosecution would put on. Well, with a grand jury, it's very different. It's a secret proceeding. Bryan Kohberger does not get notice that it's happening. He gets notice afterwards that he's been indicted, and he can go pick up his transcript, right? That's what happens in all my grand jury cases. And so there's zero participation by the defense. But what's really important, and what I've seen all over Twitter this morning, is about this idea of exculpatory evidence, right? Exculpatory evidence must be presented to a grand jury. So even though this is a very sort of one-sided proceeding where you only have the prosecutor, the judge, the 12 jurors, the grand jurors, in the room with a court reporter, right? You have to still represent the evidence that is perhaps favorable to the defense, that might be, exculpatory to them. You can't just go in there with all the receipts and the incriminating evidence. And so this is a very interesting timing, because there has been a lot of back and forth about discovery outstanding to the defense, and this idea that the defense is pounding the table saying, there's exculpatory evidence that you owe us that you have not given us. Where is it? And so I think the prosecution went ahead with this grand jury ahead of the preliminary hearing now, so that, in case there's any leaks or anything, that the grand jury would be the first to essentially hear all of this evidence. So again, very interesting timing. And I'm wondering what your questions are about the indictment. So I'm going to put my glasses on because I can't see that good from this distance. But Matthew is asking, Have we confirmed that the trial will be televised? We have not. Right now, there is a gag order in place, and I would imagine that this court wants to keep everything sort of really tight to the chest, and that the trial would not be televised, which of course just doesn't make it fun for the rest of us, right? We want to really hear what's happening. We just saw with Vallow, the trial was not televised, and we had to rely on great reporting, but still reporting and not really sort of seeing it for ourselves. And we don't know if that's going to be the case in Idaho. I just want to briefly address the gag order issues because it goes to Matthew's question. So, on February 6th, there was a coalition of media that filed a writ with the Idaho Supreme Court saying the gag order should be lifted. The media, the public has an interest in the, incredible newsworthiness of the story. February 27th, the magistrate, the level at which Kohberger's case is now, magistrate court, delayed Gonsalves. That's one of the victims. The Gonsalves family had filed a motion pending the Supreme Court decision, essentially wanting this gag order modified so they could go give interviews, like on NewsNation, for example. And so the magistrate delayed that because it sort of related to the same issue that the media raised in the Supreme Court. And then on April 24th, the Supreme Court said that everybody needs to first seek relief in the magistrate, the lower court, before we can issue a writ. Essentially what was being asked of the Supreme Court was a writ of mandate, lifting the gag order. So essentially that's sort of the procedural issue. And then on April 28th, the magistrate court set the Gonsalves motion for May 25th. And then on May 2nd, the media coalition came in and filed with the magistrate court as directed by the Supreme Court. And then on May 4th, the magistrate vacated that May 25th hearing and instead set it for a scheduling conference. So that's where we're at essentially now. And once this hearing gets set, at the hearing, we'll see whether this gag order is modified as to the Gonsalveses, whether it's modified or lifted altogether. The defense, of course, probably wants this in place. But I have to say this from my perspective as a defense attorney. Gag orders tend to benefit the prosecution. And that is because usually the leaks that occur are spun and disseminated in favor of the prosecution. And what that does to the defense is essentially the defense is bound by the gag order. They can't defend against those leaks, but yet those leaks happen. So it's interesting because there's been so much going on about this case that is rumor, that is not fact. And then there's analysis of the rumor. And so the gag order is very telling, I think, as to also whether this trial would be televised down the line. We have another question from Jalen on Facebook asking, when would we hear if they want a change of venue? I mean, look, I think they can make that motion at any time before trial, but they have to have good reason for it. And what I've always said about this case is I don't think there's any place in Idaho, in Washington, in the entire United States that is going to be a fair venue where both sides will get a fair trial, will get a fair jury that's not tainted. And this is just because the incredible national coverage of the story that I just think no place is a fair venue. And by the way, both sides have an interest in wanting a venue that provides a fair and unbiased jury that is untainted, because obviously from the defense side, we want the defendants to get a fair trial. The prosecution also wants the defendant to get a fair trial, because if not, it raises an appellate issue and it could potentially overturn a conviction. So it's an interest for both sides to have a venue that's fair. Where that is, I don't think in this case we have one. Let's see, are there any other questions? If we don't have any questions coming in, Doug. Okay, hi, Doug from Facebook. Has the defendant acquired his own private defense? I imagine you mean private defense attorneys. No, in fact, recently there was a new attorney added to Ann Taylor's team who was specific to the death penalty issue. And there was a lot of criticism of her that, her old profile somewhere on the deep web says that she was a real estate attorney. Listen, I might have stuff out there that's so old that I don't get around to checking, let alone modifying. She, in fact, has a lot of experience, this new lawyer, in death penalty cases, specifically in the mitigation aspect. And that's very important to a death penalty trial, part of the trial, because it's about aggravating factors and mitigating factors and why the defendant should or should not get the death penalty. So she came in for a very specific purpose. I don't know if Kohberger at some point might hire private counsel, and if so, then all of these lawyers will go away. You don't get to keep one or two from the county and then bring in your private counsel. It's you either go private and you pay for it yourself, or you get the help of the county through court-appointed attorneys and private and public defenders. So we don't know yet, but he can certainly exercise his right to a lawyer of his own choice at any time before trial. We have someone on YouTube asks if the June 26th date is still in place. No, it's vacated. You don't get two bites at the apple, right? The prosecution gets one hearing at which it presents evidence of probable cause that the defendant should stand trial. Now, if they filed a complaint, which they did, a preliminary hearing would be set, which it was for June 26th, like this viewer said. And that's where both sides would get to participate. Prosecution presenting evidence, defense poking holes and challenging the evidence. And then the judge would decide whether there's enough probable cause for the defendant, for Kohberger, to go to trial. But they decided they didn't want to do that for good reason. And they indicted by grand jury. So that grand jury determined that there was probable cause and that Bryan Kohberger should go to trial. So now that they have an indictment, that's it. We're now in the pretrial phase, and then we're going to get a trial date. They're not going to get to then get another bite at the apple at a preliminary hearing. I mean, I bet the defense would want that. I would want that, but they only get one shot, and they chose to go with the indictment. April from Facebook is asking, do you think that the trial could be in 2024 or 2025? God, that's always such a strange time estimate, right? Like, for example, with the Alec Murdaugh case, for those of you who followed that case, I was shocked that the trial went so, I mean, within less than a year, within like 6 months, the trial started. But that was a case where the evidence was so skim that I would also schedule it for an immediate trial, because I wouldn't want the prosecution to use more time, to be more prepared, to gather more evidence. Of course, things went south in that case for different reasons. But in Kohberger, there is like just tremendous amount. I mean, it's the evidence and the discovery is voluminous, even though all of it has not been turned over. Some of it is still being processed and then has to be produced. Multiple counties being involved in his investigation and arrest, and the FBI. It is a massive case in terms of evidence and circumstantial case. So in a case like this, I would think that it's definitely not going to be 2023. If I were to, be a psychic here, probably going to be 2024, possible that it could be 2025, but definitely not this year. And it's really because of the tremendous amount of evidence that the prosecution, some of which has turned over, some they still owe, as we know from these discovery requests, and then the motion to compel that the defense recently filed. So the defense is saying, look, we don't even have what we need to then do our own independent investigation to be able to prepare for trial. So when you think about the totality of this, we still have evidence that's not processed according to the prosecution's responses. The prosecution then has to process and turn those items that are outstanding over. And then the defense needs to be able to do its own independent analysis, hire experts, go through the DNA analysis, go through the cell tower issues. And this is going to be a very heavily expert-driven trial. There's going to be a battle of experts 100%. So when you put all this together, there's no way, now we're coming up, pretty soon, you blink of an eye, you're going to have Thanksgiving, you're going to have Christmas, that stuff already, summer vacations, delays trials. And it's not happening this year, likely middle to end of next year, maybe into 2025. That's my guess. People are asking about what is happening on Monday. On Monday, Bryan Kohberger is going to appear in Latah County Court, District Court, before the district court, and plead not guilty. It's his arraignment. So much like at the beginning of the case, he had to show up and plead not guilty to the complaint, he's going to plead not guilty to this indictment by grand jury. Now, it's really interesting. Whenever I see the headlines when a high-profile defendant gets arraigned, people say, "Oh my God, he pled not guilty, but he's so guilty. Why did he plead not guilty?" And it's like, The best way I can explain it is, well, you're throwing in the towel and you're done. I mean, there's no trial if you go in there and plead guilty. So it's a matter of it's as a matter of course, you're going to plead not guilty, and then you're going to have an opportunity to defend yourself against the charges, and then you either change your plea to guilty if you're taking a plea deal, which is not happening here, or you go to trial and then let the jury decide whether you're guilty or not guilty. But arraignment, you really always plead not guilty. So that's what we can expect on Monday. Are there any questions from viewers about the discovery battle that we've been seeing unfold? Apparently, the defense had made 3 formal requests for discovery from the prosecution, and they claimed that there's been non-compliance, essentially lots of items outstanding, and then they went ahead and filed a motion to compel, which is being heard, I believe, on May 22nd, I believe 22nd or 25th. I'm confusing those. There's 2 court dates coming up. So the prosecution is saying, oh, we turned over 30,000 photos and 10,000, terabytes of whatever. I mean, they're going through quantity. And I always say it's not about quantity. It's about news of whatever you turn over. What is it? Does it respond to what the defendant is owed? Does it cover what you did in your investigation and what you need to turn over? Now, Rule 16 of the Idaho criminal rules governs discovery in Idaho. And basically, if you read this rule, which I sort of skimmed through, I don't practice in Idaho, but it says that exculpatory evidence is mandated to be turned over. In other words, the defense doesn't even have to ask for it. The prosecution has to turn it over. And then it goes on to say there's a slew of items that the prosecution has to turn over upon written request by the defense. So the defense is saying, we've been requesting, you're not giving it to us. It's a very interesting issue to me, because when I read through these requests and these responses by the prosecution, there are items that are baffling to me, like the notes that the officers took in their investigation. They're saying that we still need to review them before, and notes should not take that long. Notes should not take that long to copy, produce, review before you do that, because they're in real time. An officer does an investigation, does an interview, takes a statement. They make notes. And so why are they not turning that over? There was genealogy related to the DNA genealogy related to familial DNA they picked up from the trash bin in Pennsylvania outside the family home that I guess connected Bryan through his father, essentially, to the knife sheath. And so that has been questionable, although they're saying, we'll give it to you. Maybe it's not relevant, but we need a protective order. And it tells me that maybe the company that did that analysis, because it's still relatively new science, is objecting to its production just because of the incredibly sort of intrusive nature of it. There's a lot of issues, and I think a lot of the items will be compelled to be produced, but the defense has to go to a hearing. They have to be heard by the judge, and the judge then has to decide, okay, what is it that you should be turning over now that you're going to trial? It's not even a prelim, like you're going to trial. The prosecution cannot decide what is relevant or not relevant for the defense. In other words, the prosecution can't make the call that, oh, yeah, we have this, but you don't really need it because it's not relevant. No, if you did an investigation based on certain evidence and you gathered evidence based on that investigation, you have an obligation to turn it over, especially now, because you may not want to use it, but the defense may want to use it. So it is very interesting to me, you guys, this issue of exculpatory evidence that's been persistently asked for in these discovery requests by the defense, and this idea that now we have a grand jury indictment. Given the obligation that the prosecution has to present exculpatory evidence to a grand jury, I have to hope that they in fact did that, because in their responses, it sounds like they think they get to decide if something is relevant and exculpatory. So that's going to be, I anticipate, some feud over what is owed and whether or not it's disclosable because it's exculpatory. Someone on YouTube asks, would they take the death penalty off the table if he pleads guilty? That's certainly always a consideration and an incentive. I don't see it happening here. You've got 4 victims. This was a very, very brutal killing. And if the evidence checks out, and in fact, the prosecution meets its burden beyond a reasonable doubt that Bryan Kohberger was in fact the suspect who killed these four students in the way that he did, right? There are a lot of factors that would support the death penalty. Vulnerable victims, it was early in the morning, they were asleep, he basically was lying in wait and he had scoped the house. If all that evidence with the cell phone pings and all that checks out, which is very problematic in every case, it's challengeable, but then that's tremendous evidence of guilt. And I don't see why the prosecution would ever take that off the table in a case like this. But certainly, and generally speaking, it is a consideration when the defendant tries to plead out, as opposed to waste the resources and time of the court and the county by going to trial. Carrie from YouTube asks if the grand jury proceedings are still secret. Can they be interviewed? No, it's a secret proceeding. We're not going to know who these jurors were. We're not going to really know, those intricate details that we would normally when we're in a courtroom. But the defense is absolutely entitled to the transcript. The transcript is not secret. There's a court reporter in that courtroom for a reason, and they will transcribe everything that is brought to the grand juror's attention, the direct examination of witnesses, any inquiry by the judge, any questions that the jurors might have. All of that would be transcribed, and that is not a secret. Now, whether the public will get it is a different story, again, because of the nature of these proceedings. But the only thing that's secret is the proceeding itself. Are there any other questions about the gag order, discovery battle, and this indictment today? And Monday's arraignment, of course. Does our producer think that I left do we know the motive? We don't. There's been so much said about he's a psychopath. He hated girls. He was rejected. He's an incel. He's this, he's that. I mean, profiling galore, and not just by former FBI profilers who I have tremendous respect for, but just by very salacious reporting and the general public about how everything that he's done, from the way he reacted, upon his arrest to today, that he's a narcissist and he killed these girls because he really was after one of them, was connected with one of them on social media and sent something to her, even though she never responded. And so he hated her for not responding. It goes on and on and on. And I think we really need to take a breath and wait to know more. We have not seen any of this stuff to really be able to formulate that it was him and that, that he had the motive to do it or what the motive was. Now, I have to say this, as you all know, following different stories lately in the crime world, motive is not an element of murder. And so the prosecution never has to prove motive. But of course, every juror, every person wants to know why. That's the biggest question. That's the $1 million question. So of course, a jury down the road in Kohberger is going to want to know why this guy's going to this university in Washington. Of course, these towns are close. He's going back and forth, partying, whatever. He's part of the same sort of larger clique. But why any one of these girls, let alone all four, or the victims? Sorry, there was one male. That's a good question in this case, and I think the prosecution needs to have a motive in this case. But what that is, we just don't know, because there's just been so much BS circulating about this particular defendant. Do we expect to learn more before the trial? I think that's going to largely turn on this gag order ruling, right? We have to see what the magistrate court rules later this month on the gag order, or whenever the hearing is set, because I think it's set for scheduling initially. And from there, if then any of the parties move back to the Supreme Court in Idaho on the writ of mandate, we have to see what ultimately the highest ruling is on this gag order, because if it's modified and lifted, we're certainly going to know more factually as opposed to rumors, right, around this case. And that's really my hope. I'm a lawyer. I am about the process. I'm about protecting people's constitutional rights, and nothing irks me more than when I hear lies and rumors and convictions in the court of public opinion. And so I do hope that we get to see more factually, and we get to be in the courtroom somewhere down the road. But I think what we'll learn is going to depend on this gag order, frankly. Anyway, I think I've hit on all the important points that I sort of have gathered from all of you on Twitter and on NewsNation's page. And then, of course, those of you who are nice enough to tune in today and ask the questions live. I hope to do more of these with you. Please stay connected with me and NewsNation, because we will bring you always the best reporting on all of these high profile cases in the news that make headlines, and also the ones that really should make headlines that we dig up and we think you need to know about. So stay close to NewsNation, and it was wonderful joining you this morning. Thank you.